So that's our mission today. We're looking at the legal briefs, the congressional statements filed just this month, and the DOJ's own internal defense memos. We're going to figure out why the files aren't out, who specifically is stopping them, and whether the law designed to release them was, well, broken from the very start.
And we should warn you, this isn't just a story about some scandalous list. This is a story about a constitutional crisis. It's about what happens when the people we elect tell the bureaucracy to do something, and the bureaucracy just says no.
So let's rewind to the origin point. To really understand the mess we are in today, on January 18th, we have to look back at November 2025. This all started with a piece of legislation that moved through Washington at a speed that is, frankly, suspicious.
It was faster than almost anything we've seen in decades. We are talking about the Epstein Files Transparency Act, Public Law 11938.
Right.
Usually bills like this, they die in committee or get watered down for months. This one passed the House of Representatives on November 18, 2025, with a vote of 427 to 1.
Okay, pause on that for a second. 427 to 1.
In this political climate.
We can't get 427 votes to agree on the color of the sky. Who was the one dissenter?
Representative Clay Higgins from Louisiana. He was the only no. But the momentum didn't stop there. It went to the Senate the next morning and passed by unanimous consent.
Unanimous consent.
President Trump signed it later that same day, November 19th.
So unanimous in the Senate, basically unanimous in the House, signed by the president. This wasn't a suggestion, it was a mandate. What exactly did this mandate require the government to do?
Well, it was designed to be a forced disclosure. The law gave the Attorney General exactly 30 days to release all unclassified documents, flight logs, all of it, all the investigative materials related to Jeffrey Epstein and Ghislaine Maxwell.
And the deadline was?
December 19, 2025.
When you say forced disclosure, that sounds legally different from like a simple Freedom of Information Act request.
It is. A good way to think of it is like the JFK Records Act of 1992. That's the historical parallel here.
Yeah.
Occasionally, Congress decides that an agency, in this case the Department of Justice, is stonewalling the public. So they pass a law that effectively strips the agency of its decision-making power. They say, you don't get to choose anymore. You have to release everything.
And who does this apply to? I've seen some confusion online where people think this law forces private citizens to hand over their hard drives.
No, that's a critical distinction. The Act targets the executive branch, the DOJ, the FBI, U.S. attorneys. It applies to documents the government already has.
The stuff they already seized.
Exactly. It doesn't force Bill Gates or some random person to open their safes. It is about government transparency on their own investigation.
Okay, so the government has the files. The law says release them by December 19th. And crucially, the law also put guardrails on how they release them, right? They couldn't just dump 1 million pages in a warehouse somewhere.
Correct. The law mandated that the files be digital, searchable, and downloadable. But the most aggressive part of the statute, and this is where the current fight is really happening, is the anti-redaction clause.
Oh, this is key.
The law explicitly forbids redactions based on embarrassment, reputational harm, or political sensitivity.
That is the kicker. Usually when we see government document dumps, half the page is just blacked out with that Sharpie marker, and the excuse is always privacy. This law specifically says you cannot use privacy to protect a public figure's reputation.
Exactly. It removes the embarrassment shield. If a senator or a prince or a CEO is named in some compromising context, the DOJ can't redact it just to save their career.
So the table was set. The deadline was December 19th. Let's flash forward to today. Mid-January 2026. What is the scorecard?
It's an F, a failing grade. I mean, it is a matter of public record that the DOJ missed the statutory deadline completely.
Give us the numbers. How much is missing?
Well, the estimated volume of materials is somewhere between 2 million and 5.2 million pages. As of this week, they have released approximately 12,285 documents.
That is, let me do some quick math here. That's less than 1%?
Oh, significantly less. It's a trickle. And the documents they have released are mostly things that were already out there, in the public domain or leaked years ago. The new material, the stuff this law was written for, is still locked up.
This isn't just a delay. That sounds like non-compliance. Who is actually responsible for this?
Yeah.
Because the DOJ is a building. There are people inside making these calls.
Right, and while this isn't a criminal breach in the sense that someone is going to jail tomorrow, there are specific officials who are administratively responsible. At the top, you have Attorney General Pam Bondi.
Of course.
She is the head of the department, so the buck stops with her. She is facing calls for impeachment, for contempt.
But she's not the one on TV explaining the delay, is she?
No, that role has fallen to the Deputy Attorney General, Todd Blanche. He is overseeing the document review team, and he's been the public face of this slow roll.
And there's a third person, right, from New York.
Yes, U.S. Attorney Jay Clayton of the Southern District of New York.
Why is the Southern District so involved?
Because the SDNY, the Southern District, that's where the original Epstein and Maxwell prosecutions happened. So they physically hold the most sensitive files. And Jay Clayton is in federal court right now, fighting tooth and nail to keep control of them.
Okay, so Bondi, Blanche, and Clayton, they aren't just sitting there saying, we don't want to. They filed these extensive legal briefs explaining why they missed the deadline. Their claim is, what, logistical impossibility?
That is their defense, yes. They argue they are not defying the law, they are balancing it. And if you look at the DOJ's internal memos, they rest their case on 4 main pillars.
Let's break these down because some of them sound reasonable on the surface, but I want to test how sturdy they really are. What's pillar number 1?
Victim privacy. This is based on Section 2C of the Act. The law says the DOJ must redact personal information of victims to protect them.
Okay, fair enough.
So the DOJ argues that if they rush to publish 5 million pages, they will inevitably miss something and accidentally expose a survivor's identity or, their medical history.
Which is a valid point. I mean, nobody wants a victim doxxed because a paralegal was rushing.
Exactly. They argue that an accidental release of victim data would be a separate and maybe worse violation of the law. So they're claiming the moral high ground. We are delaying this to protect the innocent.
Okay, that's the moral argument. What is the second pillar?
Volume and complexity. This is what they are calling the sudden discovery. In late December, just as the deadline was hitting, the DOJ claimed they found an additional 1 to 2 million pages that weren't even in the original index.
Wait, how do you just find 2 million pages? That's not like a misplaced file folder. That's a warehouse.
Their explanation is pretty vague, something about archival inconsistencies. But the result is they now claim they need to manually review this huge new tranche of documents. They have a team of 500 attorneys on it, but they say you can't automate it. You need human eyes on every page.
So the homework is bigger than we thought. What's the third argument? This one sounded more legalistic.
It is. Deputy AG Todd Blanche calls it well-settled law. He was on Meet the Press arguing that the DOJ has a protective duty to witnesses that supersedes statutory deadlines.
So safety over deadlines.
Essentially, yes. He's saying that when a deadline conflicts with safety, the department has the discretion to ignore the clock as long as they're working in good faith.
Good faith is doing a lot of heavy lifting in that sentence for a team that's released less than 1% of the files.
Precisely. And then there is the fourth pillar, which is the one that's been mocked the most online. Technical glitches.
The server crash, of course.
Yes. The DOJ is claiming the sheer volume of the digital uploads is causing server instability and crashing their public portals. They say they need around-the-clock IT support just to keep the site live.
I have to call nonsense on this one. This is the United States government. They run the NSA. They run the IRS. They communicate with rovers on Mars.
Right.
And they're telling us they can't upload a database of PDFs.
It is a very difficult argument to swallow in 2026. Tech experts have pointed out that hosting 5 million pages of text is, it's trivial for modern cloud infrastructure. It really feeds the skepticism that this is less about capability and more about a stall tactic.
Well, the skepticism isn't just from tech experts. The sponsors of the bill, Representatives Ro Khanna and Thomas Massie, they're furious. They're not buying the glitch excuse or the privacy excuse.
No, they have moved way past skepticism to open accusations of bureaucratic sabotage. They believe the DOJ is exploiting loopholes in the law to deliberately run out the clock.
Okay, let's look at those loopholes. This is the poorly written theory. You mentioned Section 2C, the victim privacy clause, earlier. How does a clause designed to protect victims become a weapon for secrecy?
Rep. Massie calls it the Achilles heel of the entire act. The problem is that the law didn't strictly define who counts as a victim in every single context, or how much context needs to be removed to protect them. This is the permitted withholdings clause.
So it all comes down to interpretation.
Right. And the accusation is that the DOJ is using what they call a black highlighter approach. If a document mentions a victim, but it also mentions a senator doing something terrible on the same page, the DOJ might just redact the entire page, claiming it's necessary to protect the victim's privacy.
So the privacy of the victim effectively shields the perpetrator.
That is the argument. Critics say the DOJ is weaponizing privacy. By claiming they need to meticulously check for victim names, they justify the delay. And by redacting broadly, they hide the high-profile names.
And what about that sudden discovery of the extra million pages? Khanna had some really strong words about that.
He called it highly suspicious. The theory here is that you flood the zone with extra material as a strategy to make the whole task look logistically unmanageable.
Make it look impossible.
Exactly. If the job looks impossible, a judge is way more likely to grant them a multi-year extension.
Multi-year.
If the DOJ convinces the court that manual review of 5 million pages is required for safety, we could be looking at a timeline that stretches into 2028 or even 2029.
Which just defeats the entire purpose of the emergency legislation. So let's talk about what is actually missing. We know 99% of the files are being held back. What exactly are we all looking for? What is in that 99%?
Well, there are two holy grails here. First, the FBI 302s.
And define that for us. What is a 302?
It's Form FD 302. It's the official report an FBI agent types up after an interview. It contains exactly what was said, who said it, the agent's impressions. These are the raw narratives of the investigation.
So if a witness named a co-conspirator,
it would be in a 302, and those have mostly been kept secret.
And the second item,
the internal memo regarding the 2008 non-prosecution agreement.
The famous sweetheart deal.
Exactly. Back in 2008, Epstein was given this incredibly lenient plea deal that also granted immunity to any potential co-conspirators. There is an internal DOJ memo that explains why that deal was offered and who authorized it.
Okay.
That memo is expected to name the high-level figures who pressure the prosecutor to let Epstein off the hook.
That is the document that could end careers. So we have a standoff. The DOJ says, we are trying, but it's hard. Congress says, you are sabotaging the law. What happens now? If I break a law, I get a ticket. If the Attorney General breaks a law, what's the mechanism?
That is the million-dollar question. Since the Transparency Act didn't include self-executing penalties, meaning it didn't automatically fine the DOJ for being late, Congress has to use external force.
They have to get creative.
They have a menu of options ranging from standard to nuclear.
Okay, walk us through the menu. Option 1 is the courts, right?
Yes. Judicial intervention. This is happening right now. Reps Massey and Khanna have filed a motion asking a federal judge to issue a writ of mandamus.
A writ of mandamus? That sounds medieval.
It's an ancient legal concept. It's just a court order that commands a government official to do their job. It's the court saying, this isn't a suggestion, do it.
And if the DOJ ignores that,
then they can be held in contempt of court.
Which could lead to what? Fines.
Heavy daily fines, or, and this is what Jay Clayton is terrified of, the appointment of a special master.
Explain the special master role. It sounds like a character from a sci-fi movie.
In this context, it's a total game changer. A special master is an independent third party appointed by the judge. They would essentially march into the DOJ, take custody of the hard drives, and strip the DOJ attorneys of their authority to review the files. The special master decides what gets released.
So the DOJ basically gets fired from their own investigation.
Exactly. It removes the conflict of interest. The argument is you can't ask the suspect to curate the evidence against themselves. The DOJ shouldn't be deciding which DOJ mistakes to release to the public.
That seems like the most logical path.
Yeah.
But you mentioned a nuclear option, something Congress can do directly.
Inherent contempt. This is rare, it's dormant, and it is incredibly dramatic. It comes from the idea that Congress has its own police power to enforce its own rules.
Police power? You mean like the Capitol Police?
Specifically, the Sergeant-at-Arms. Under inherent contempt, the House of Representatives can vote to bypass the DOJ entirely. They can order the Sergeant-at-Arms to arrest an official, even the Attorney General, and detain them until they comply.
Wait. So theoretically, we could see a situation where an officer of the Congress walks into the Justice Department with handcuffs.
Theoretically, yes. It has not been used in nearly a century because it's just so confrontational. It would provoke a massive constitutional showdown. But the fact that Massey and Khanna are even threatening it shows you how high the tension is.
Wow.
Their argument is, since the DOJ won't prosecute itself for contempt, Congress has to do it themselves.
And there's also the power of the purse, right? Just cutting off their allowance.
Yes, fencing off funds. Congress can pass a rule saying the DOJ cannot spend a single dollar on the Attorney General's staff salary until these files are out. That's often very effective, but it takes time.
So bring us to right now, today, January 18th. Where does the chessboard stand?
The debate has totally shifted. It is no longer, when will they release the files? It is now, is this sabotage? And the focus is entirely on Judge Paul Engelmayer.
He is the federal judge overseeing this case.
Correct. Massey and Khanna have formally requested that Judge Engelmayer remove the DOJ from the process and appoint that independent special master immediately. Their filing argues that the DOJ has proven it just cannot be trusted to grade its own homework.
It makes sense. If the delay is truly just technical glitches and victim privacy, then an independent special master can handle that just as well as the DOJ can.
But without the conflict of interest.
Right. An independent party doesn't have an incentive to hide embarrassing political connections. They just have a mandate to release.
Exactly.
So we are waiting on a judge's ruling. It really feels like we're on the edge of a cliff here.
We are, and it raises a really uncomfortable question for all of us, regardless of your politics. It's a question of governance. If a law is passed unanimously by the Senate, almost unanimously by the House, and signed by the president, but the unelected agency responsible just says, no, it's too hard, who is actually running the country?
That is the core issue. Is it the elected officials, or is it the permanent bureaucracy?
Exactly. Is this delay just incompetence and bad servers, or is logistical impossibility the perfect cover for a continued cover-up? That is what Judge Engelmayer has to decide, and that is what the American public is waiting to find out.
Well, that is a terrifying thought to leave us with, but it's the reality of the moment. We will be tracking Judge Engelmayer's decision very closely. As soon as there is movement on the special master, or if the sergeant-at-arms actually starts warming up the car, we will let you know.
We certainly will.
Thanks for listening to this deep dive. Stay curious, stay skeptical, and we will catch you next time.